5 seconds to go. Start. Learned APP for the state further added that the testimony of the victim is corroborated with the medical evidence, that is MLC of the prosecutrix, as hymen of the victim was not intact, which is sufficient to credit the version of the prosecutrix that she was sexually assaulted. She further submitted that the absence of major external injuries on body of the prosecutrix on the date of her medical examination would not necessarily mean that she had not been sexually assaulted or she had not resisted during the time of assault. Based on these submissions, counsel for the state urged that this court may not interfere with the well-reasoned order passed by the learned trial court convicting the appellant for the alleged offence. We have heard the learned counsel for the parties and carefully examined the impugned judgment and the material available on record as well. It is a settled principle of law that in cases involving sexual assault, rape, it is generally difficult to find any corroborative witnesses except the victim herself, and therefore the evidence of the victim is sufficient for conviction unless there exist compelling reasons for seeking corroboration. Thus, a conviction can be sustained on the sole testimony of the prosecutrix if it inspires confidence. The apex court has time and again held that the sole testimony of the prosecutrix is sufficient to hold the accused guilty if it inspires confidence, and the same principles have been reiterated in Vijay versus State of Madhya Pradesh, reported in 2010 8 SCC 191. Relevant paragraph of the judgment reads as under. Thus, the law that emerges on the issue is to the effect that the statement of the prosecutrix, if found to be worthy of credence and reliable, requires no corroboration. The court may convict the accused on the sole testimony of the prosecutrix. In Gagan Bihari Samal versus State of Odisha, reported as 1991 3 SCC 562, the Honorable Supreme Court of India, whilst observing that corroboration is not the sine qua non for conviction in a rape case, held as follows. In cases of rape, generally it is difficult to find any corroborative witnesses except the victim of the rape. It has been observed by this court in Hirji Bhai versus State of Gujarat 1983 3 SCC 217, 1983 SCC Criminal 728, AIR 1983 SC 753 as follows. Corroboration is not the sine qua non for a conviction in a rape case. In the Indian setting, refusal to act on the testimony of a victim of sexual assault in the absence of corroboration as a rule is adding insult to injury. Why should the evidence of the girl or the woman who complains of rape or sexual molestation be viewed with the aid of spectacles fitted with lenses tinged with doubt, disbelief, or suspicion? To do so is to justify the charge of male chauvinism in a male dominated society. A girl or a woman in the tradition bound non permissive society of India would be extremely reluctant even to admit that any incident which is likely to reflect on her chastity had ever occurred. She would be conscious of the danger of being ostracized by the society or being looked down by the society, including by her own family members, relatives, friends, and neighbors. She would face the risk of losing the love and respect of her own husband and near relatives, and of her matrimonial home and happiness being shattered. If she is unmarried, she would apprehend that it would be difficult to secure an alliance with a suitable match from a respectable or an acceptable family. In view of these and similar factors, the victims and their relatives are not too keen to bring the culprit to book. And when, in the face of these factors, the crime is brought to light, there is a built in assurance that the charge is genuine rather than fabricated. The above observation has been made by this court, relying on the earlier observations made by this court in Rameshwar versus State of Rajasthan 1952 SCR 377 386 AIR 1952 SC 54 1952 Criminal Law Journal 547 with regard to corroboration of girl's testimony and version. Vivian Bose, judge, who spoke for the court, observed as follows: the rule, which according to the cases has hardened into one of law, is not that corroboration is essential before there can be a conviction, but that the necessity of corroboration as a matter of prudence, except where the circumstances make it safe to dispense with it, must be present to the mind of the judge. The only rule of law is that this rule of prudence must be present to the mind of the judge or the jury as the case may be, and be understood and appreciated by him or them. There is no rule of practice that there must in every case be corroboration before a conviction can be allowed to stand. Stop.